Welcome back to the Law Show. I'm Mike McLeod. I'll be with you for this segment of the show. We want to thank our viewers again for watching the show and for your interest in the information that we're able to provide every week at this time on this station. Our law firm, Kerrigan, Estes, Rankin, McLeod, and Thompson, specializes in cases that involve serious injury and accidental death cases. We have limited our law practice only to this work for 40 years. And the lawyers who handle your cases here are lawyers that you meet throughout the course of our representing you. We're available to you, and we are board certified in civil trial law. And board certification is an opportunity through the Florida Bar to provide objective proof to the public that lawyers have a level of experience and expertise in certain areas. And our lawyers who handle these cases are board certified civil trial lawyers who only handle personal injury cases. We have a great website. It's Kerrigan.com with a lot of information about the law firm and all of us. You can read our 5-star Google reviews. You can read the background information of all of the lawyers with the law firm, including those of us who participate and do segments of the law show each week. So I invite you to go to our website. It's Kerrigan.com. It's on the screen now. Also, you can text me at our main number, 850-444-4444. There's the number. It's all fours. So I can receive a text if you have a question or comment about the show, and I'll try to reply to it. And also, my email address is mike.mcleod@kerrigan.com. If you have a question or comment you want to send by email, and I will reply to you. So I want to talk a little bit in this segment of the show about the differences between Florida law and Alabama law, some of the differences as it pertains to personal injury cases, accidental injury cases. And the reason is because we get a lot of viewers, even though we are Florida lawyers and have offices across the panhandle of Florida, Pensacola and Panama City particularly. We get a lot of viewers and some questions from Alabama. So there are some noticeable differences in handling these cases depending on where your accident happened. So the main difference is that Florida's accidental injury cases are governed by negligence law that is called comparative negligence. And in Alabama, the negligence concept is called contributory negligence. So in Florida, juries compare, lawyers who handle these cases, insurance people who handle these accidental injury cases compare the fault of one party versus the fault of another party. And in a lot of accidents, the fault is 100-0. In a case where someone, we'll use car wreck cases as an example, where someone runs a red light and hits another vehicle that had a green light, and there's no question about it, and there's no question of speed or any other element to the accident, then we would conclude the accident was 100% of the fault of the car that ran the red light. In a rear-end collision, and listen, there are a lot of cases, I would say most of these automobile accident cases are rear-end collisions. A driver is inattentive on their cell phone. It's just kind of human nature sometimes. But a rear-end collision is quite likely 100% the fault of the car that rear-ends the other vehicle. But some cases are a combination of faults. And so in a case where, say, one vehicle doesn't have the right-of-way and is pulling out into a lane of traffic where those motorists have the right-of-way, so violates the right-of-way. However, the car that hits that car is going over the speed limit, then that is, I think, a good example of a case where both drivers combine to cause the accident. One driver pulls out into a lane of traffic where people have the right of way, and the car that hits him is going too fast. And so juries and insurance people and lawyers try to, in Florida, they compare the fault. And in that case, for example, let's say the car was going 20 miles an hour over the speed limit. Somebody pulls out. We might conclude that the car that pulls out is only 30% at fault, but the car that's going 25 miles an hour over the speed limit is 70% at fault. And so in those cases in Florida, you can still recover the percentage of your damages that was caused by the other vehicle. And that is called, in Florida, comparative fault. We compare the fault of both drivers. In Alabama, the concept that governs Alabama accidental injury cases is contributory negligence. So in Alabama, if the person who's injured, who makes a claim against the other driver, is to any degree at fault in causing the accident, under Alabama law, that person does not recover anything in the accident. And so in the defense of cases in Alabama, if an insurance company or a defense lawyer puts any fault whatsoever on the person making a claim who's injured in an accident, then at least in theory, under Alabama law, the plaintiff, the injured person, doesn't recover anything if they're to any degree at fault in the accident. There's even a concept in Alabama that's called the scintilla rule. And that is, if the injured person is even a scintilla at fault in causing the accident, they do not recover. Not true in Florida, where we compare the fault and where even if the injured person has participated in causing the accident, they can still recover the percentage of fault of the other driver. So that's one of the main differences in overall accidental injury law in the two states. Another difference, in Florida, by statute, if you're in an automobile accident, we'll continue to use automobile accidents as an example, you are entitled in Florida to find out the insurance limits of the other driver. And so by statute, we can write a letter. You have to request it in writing to the other insurance company who caused the accident. And that insurance company is required to tell you the insurance limits of their insured who we are have a claim against for causing the accident. So you know how much the insurance limits are, and that a lot of times can help get cases resolved, knowing if the limits are small or large. It just helps you evaluate, as a lawyer or an injured person, evaluate your case. In Alabama, insurance companies are not required to divulge the insurance limits of their insureds. And so in Alabama, if you get rear-ended by another vehicle and you have an injury and a claim, you want to know how much are the insurance limits of the person who caused the accident. That insurance company is not required to divulge those limits. And I think sometimes in those cases, it makes those cases more difficult to resolve. Now, insurance companies may, in Alabama, choose to tell you, well, these insurance limits are only $25,000 or whatever it is, because it may assist in getting the case resolved, but they're not required to tell you those limits. And I'll suggest that in both states, insurance companies don't voluntarily do it unless you ask. In Florida, you're entitled to ask, and no, insurance companies don't readily just volunteer that information. You have to ask, and we do in, of course, all of our cases in Florida. Another thing about these insurance limits in each state. So in Alabama, there are minimum insurance bodily injury liability limits that are required by all motorists who own vehicles in Alabama. And that minimum bodily injury liability limit is $25,000. And so Alabama requires all motorists to carry this coverage. And bodily injury liability coverage is coverage that applies to another person's injury. If you hurt another person, if you cause an accident, your insurance limits are at least $25,000. It's the minimum. You can certainly, and many people have higher limits than that, but at least the legislature in Alabama requires certain minimum limits. And I think a moral obligation, if we drive, to have some coverage that protects somebody in the event that we cause an accident and hurt them. Amazingly, in Florida, the legislature does not require any bodily injury liability minimum. And so in Florida, drivers, people are going to say, well, I'm required to have insurance. Well, yes, you are. You're required to have property damage liability in case you cause property damage in Florida, but only $10,000. And you're required to carry something called PIP, personal injury protection coverage, that pays on your own medical bills or lost wages. We could talk for several shows just on personal injury protection coverage, but not any bodily injury liability coverage. So it is amazing that Florida is one of the very few states in the country that does not require minimum bodily injury liability limits in the event their drivers hit and hurt another person. They can have insurance, but they can have zero coverage. Alabama has a minimum of $25,000 in coverage, which is, in our view, much better because, again, I think as motorists, we have a certain obligation to protect other people. Now, if a driver in Florida with those zero limits causes an accident and can't pay for the damages, they are at risk for losing their driver's license in Florida until they make the other person whole, and that comes up some in those situations and circumstances. And then finally, another kind of a curious difference in the two states is that in a trial in Florida over an accidental injury, Florida courts will allow a jury to assign fault to a non-party. And so recall that we were talking about comparing fault in Florida, and that is the accident could be 30% our client's fault and 70% another person's fault. In Florida, the courts, through a series of cases, Supreme Court cases, has ruled that a non-party can be blamed. So if there's another motorist, if there's a bystander who steps into the road, if there's a person who waves another car through and then the driver comes out onto a highway, a non-party, not sued in the case, not a plaintiff or defendant in the case, can be assigned fault, which diminishes the injured person's recovery. Alabama doesn't have that concept in their cases. A jury just finds whether it's the plaintiff's fault or the defendant's fault in Alabama. So we're happy to have a lot of viewers from both states watch the law show. Those are some of the differences in our accidental injury negligence law in the two states. So we're out of time for this segment of the show. Again, I'm Mike McLeod, here for all the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson. We're proud to host the law show every week at this time and hopefully provide you with some helpful information. Our number again is 850 and then all fours, 444-4444.